The purpose of this training video is to provide you with some concrete information we've picked up over the years concerning problems associated with the way lawyers enter their billable time. We have observed that there are some trends and habits lawyers use from time to time that pose a risk not only to their own professional reputations, but to our client relations. We've also found that the ability to sustain or support a bill in any given amount is a direct result of how that bill is created against the background of how well a client has been kept informed about the status of their matter. This training video will provide you with a series of very concrete examples of each of the primary problems that we commonly encounter, as well as specific remedies for how to prevent those problems from happening. Even if you believe that you already know all there is to know about billing, please pay close attention to the material that follows because it is almost a certainty that you will pick up something new. Please note that if you see something here that you don't understand or that raises a question, you should hit stop on the playback bar and make yourself a note so that you can follow up on that question at a later point in time. When you think about it, it's really pretty amazing. You can just sit down, type in time and hours, and it turns into money. It's almost like having a printing press in your basement that prints $100 bills. Who among us wouldn't just keep that press rolling 24 hours a day if we had the ability to do so? Well, there's an important thing to keep in mind, and that is this. We are not here to make money. We are here to earn money. So we have to be responsible in terms of how we use this machine called the billing program to keep the cash flowing into our business, which is an essential ingredient to our survival. It's common that you will hear us say that the anatomy of a problem is an intention and a counter-intention that oppose one another, or two competing interests. There are two problems, and each of those has a set of competing interests. The first problem is that the lawyer doesn't bill enough time to meet our firm requirements. When that happens, that's a problem. The other problem happens on the other side of the coin, so to speak, when the attorney bills too much time for what looks reasonable based upon what's in the billing description and what the client otherwise knows about the necessity of the time that was spent on that activity. So we can see that these two problems, each consisting of an intention and a counter-intention, have essentially the same two competing interests driving both of them. One is that we want you to bill as many hours as we can get out of you. To be blunt, we really love it when you bill a lot. But at the same time, if your billing entries, in light of what the client already knows about their case and what they read in the billing entry, gives rise to suspicion or questions, we can suffer irreparable harm to a client relationship or irreparable harm in bigger ways. There's a term that is commonly encountered when one discusses the ethics of hourly billing, and that term is value billing. The definition of value billing can vary greatly depending on what website you look at or what attorney you talk to. Some people use the phrase value billing to justify charging vastly more than was actually spent on an activity because of the efficiencies that have been created by a brief bank or a form bank or the repetition that you have experienced with the activity in question. And because the idea is, well, I only spent 15 minutes on this, but the client got 4 hours worth of benefit, I'll bill for 3 hours. And there are lawyers, good lawyers, who will justify that approach. The purpose of this training video is not to debate minute points of ethical philosophy, but simply to give you the big ticket items that you need to know about to keep us out of trouble. So with that in mind, we use a very simple definition for the phrase value billing. In this concept, we say the hours billed must bear a reasonable relationship to the quality of the service, particularly for any activity in which the lawyer has a choice regarding how much time to spend. By quality of the service, we mean not only what concrete advancements were made in the client's case, but whether the lawyer was actively involved in an activity that is reasonably necessary in furtherance of the client's interests in that litigation. When we talk about the question of whether a lawyer has a choice regarding how much time to spend, we're taking into account that there are some incredibly wasteful activities that take lots of time, and that the lawyer really has no choice about whether or not to engage in those activities. Picture an 8-hour discovery battle in court in which the attorney has absolutely nothing good to report to the client. The 8 hours in court were not optional. The lawyer had no choice. And on those types of time entries, an attorney will rarely receive criticism for the amount of time spent, particularly if the client understands what was happening. There is a particularly useful remark that's contained on the American Bar Association website, and it comes under a heading that was put there by the Bar Association that says 3 keys for effective invoicing: detail, detail, detail. Well, we'll cover when and how that rule can be applied later in this video, but basically let's take a look at what this says that really matters. It says the description area for each time entry in the invoice is a prime spot to inform the client with specificity what tasks the lawyer or the staff has performed on their behalf. Now remember, this is no substitute for a status report, and as you'll see later, we've seen billing entries in which an attorney tries to explain what was going on in the case as a substitute for a status report. Billing entries of that type are considered narrative billing entries, and they are to be avoided. More on this later. Now, there are 3 huge factors that contribute to whether or not a billing entry is what we would call dangerous. For each of those 3 factors, we have a specific solution. Here are the 3 factors that constitute dangerous billing. 1. If a client spots even one abusive billing entry, then years of work to build a client relationship can be destroyed instantaneously. 2. If the client thinks that the billing entry is abusive, then it's abusive, even if it isn't. There's an old adage, the customer is always right. Now, we've all had experience with unreasonable clients who nitpick bills, and we both know that the client's just being manipulative. This training video is not intended to provide a remedy for that situation. That circumstance is sort of a special case or a special problem that we will cover in other training materials. What we've provided here is based on the assumption, which is mostly true, that the client is both ethical and somewhat uninformed both about the law and about what's going on in the case, and for that reason you have to be very careful what you put in the billing description and how much you charge for various activities. Now let's look at how we can solve each one of those 3 specific problems. 1. The client spots a bad billing entry or a questionable entry and loses trust in you almost overnight. Solution: be very careful with every entry. There is no room for slop or just slathering on hours to get your statistics for the week up, because the price that can exact from us down the road can be catastrophic. Every entry has to stand on its own. Now, this second problem is similar and related, but has a different solution. If the client thinks the entry is a problem, then it's a problem. How do you solve that? Learn to look at the bill from the point of view of a client, not from the point of view of an associate trying to justify what they did, but from the standpoint of a client who's afraid he's spending money and getting nothing in return. Start with that mindset when you review your own billing entries. Review them as you put them in, and review them again later when you look at the entire bill. Although an entry has to stand on its own, each individual entry is judged separately. You're still looking at where that entry fits in the big billing picture as part of an overall billing pattern. We'll talk more about that later. The third issue here is that if the client thinks that the attorney is charging unreasonably in light of the importance of the task, that's usually because they don't understand what was achieved or why the task was necessary. The solution to that is not found in the billing entry description itself most of the time. Instead, that's going to be a question of whether the client's expectations about the future bill he or she will receive has been adequately managed through quality reporting. A status report that explains to a client why a problem existed, what was necessary, how it was solved, what you did to solve it, and what you achieved in that process will pave the way for a bill that follows. If the bill comes before reports like that have been received and understood by the client, then the bill is that much more likely to be a problem, even if everything on its face passes muster according to the rules that we give you here. Now let's talk about some specific examples. General principles are great, but when you see how they're applied, they make a lot more sense. So we're going to use this format. We're going to look at a sample billing entry, most of which have been taken from real bills, and we're going to talk about whether they're good or bad. Take a look at this entry in white. Received and reviewed motion to expedite briefing schedule for Hach's motion to strike new factual allegations advanced by In-Situ in response relating to summary judgment. Now, aside from the grammatical discontinuity in the last line or two, we see that this is essentially a very acceptable billing entry. The grammatical inconsistency is simply the phrase in response relating to summary judgment. That's a little awkward and a little bit confusing, but otherwise this billing entry is just fine. Now let's look at a different billing entry. This is a real billing entry that we found in our worksheets. Continue drafting defendant's section to the proposed pretrial order. Well, aside from the grammatical misuse of the word to, it should be for the proposed pretrial order or for inclusion in the proposed pretrial order. That's just a grammatical note. We have a very short description with a very long billable time entry, 5.8 hours. What was this? How could that be justified? That's a lot of time. On its face, it simply looks excessive. If I were looking at a bill as part of an audit for an insurance company and I saw an entry like that, I would immediately ask to be provided with copies of what was drafted, because that would be an easy way to do a partial instantaneous audit of the billing. Now, let's examine how the billing entry itself could have been modified. The first and easiest way to do that would be to break that task down into specific individual operations and have separate billing entries for each one, especially if those billing entries make it clear that you're not just billing for the same task over and over, and that each one of the sections that you drafted was a different part of the order. Or if you want to have a single entry that covers 5.8 hours for that drafting activity, you could say, continue drafting sections of Final Pretrial Order, including statements of disputed and undisputed facts, summary of testimony of all witnesses, and details related to claims and defenses, including the counterclaim. Now, if you're a client who's being asked to write a check, and keeping in mind that 5.8 hours is going to cost invariably more than $1,000, wouldn't you feel better about writing that check for that entry with what you see in the lower description instead of what's in the upper description? You'd understand from that description something about the depth of what was done, and this was accomplished in this entry without using an overly verbose or narrative entry. And we'll talk later in this process about what is an overly verbose entry and what is a narrative entry. But for now, it's sufficient that you understand how 5.8 hours of billable time could be justified more readily by a description that contains some additional detail. Over the years, it's come to our attention, rather dramatically on some occasions, that when an attorney is criticized or even questioned about a billing entry, the attorney can start to become resentful, self-righteous, or downright angry. There's a simple fact that must be kept in mind. We are behind the 8 ball all the time because we are lawyers and society doesn't trust us. A cold hard fact. Some attorneys take offense at criticism of their billing entries, and this is invariably seen as a sign that they feel guilty. When the lawyer becomes defensive about a billing entry, it's almost like a guilty plea. So you need to be very willing to discuss your billing entries openly at all times. Because A, you realize that the billing process is inherently perilous, and B, if you do this one thing well, you're that much closer to being a world-class practitioner. A principle that's senior to all of this is this one thing. You have to always be prepared to defend your billing entry on the face of what you write, against the background of what you've written in status reports, and in the face of any questions that survive those two issues. If you're confronted directly by your senior management or the client or anyone else, that you are ready, willing, and able to stand by and prove the reasonableness of what you've billed for. Over the years, when we've brought this issue up with younger lawyers or less experienced lawyers, we frequently hear this, but I really did spend that much time. Please, spare yourself the embarrassment and do not ever fall back on that. It will never support your weight. In the immortal words of Shakespeare, methinks thou doth protest too much. The issue is not how much time you actually spent. The issue is not how much time you actually spent. The issue is not how much time you actually spent. What matters is how much time the client thinks you should have spent, coupled with what the average lawyer of reasonable, adequate skill and ability would have spent. It's a partially objective standard, a partially subjective standard. There is a range of time within which lawyers will vary based on their ability. There is time beyond which anyone who has a reasonable degree of experience in this field will say that a billing abuse appears on the face of the bill. So if you want to come back and say, well, I really did spend that much time, you are already aware that you have fallen into a trap out of which there is little room for escape. It is much simpler to bill in a way that simply avoids raising questions in the first place. We use the word prophylactic to mean preventative medicine. So we use prophylactic practices in our billing. Let's take a look at this example, another real-life example from a real worksheet. Draft detailed correspondence to opposing counsel regarding perceived deficiencies in plaintiff's discovery responses related to their disclosure of customer names, 1.9 hours. Now the description itself is excellent, well worded, but it would not by itself support nearly 2 hours because it simply doesn't explain enough about the activity to justify a time entry that large. It could be an acceptable entry, it's just not an ideal entry. And what could make it a disastrously bad entry is if there's a 1-paragraph letter that would be the actual work product underlying this billing entry. Remember, it is not at all uncommon to have a file audited to see whether what was done in that file supports what was charged. So if you bill 1.9 hours for a letter, someone better look at that letter and see on the 4 corners of that document a product that's worth 1.9 hours. Now, assuming you've done that, and assuming that's all true, you could still make the thing look less inherently suspicious on its face by being more careful about how you break out your time. So for example, you could have broken this into 2 separate entries, and I've just made up examples here for you to see. One is drafted correspondence to opposing counsel responding to large number of alleged discovery deficiencies, 0.7 hours. Well, that amount of time and that billing entry together don't seem too suspicious. And either before that or after that, you could put reviewed all prior discovery responses in preparation for Rule 37 response letter to opposing counsel regarding alleged discovery deficiencies. Now, the reason I've put that after the letter, even though the activity probably took place before the letter, is that if they happen close in time to one another and the client reads them in the order I have shown here, the second entry seems to make more sense in light of the first entry, and it's pretty clear that they go together. But if you were to use these two entries and put them in reverse order, an argument could be made that you're using a better practice. Nothing on these lines is cast in stone. These are just principles that we're trying to demonstrate to you. Now, this is a true story. I'm going to tell you a story about a man named Sledge, a poor lawyer who could barely keep himself fed. And then one day he was shooting for some dough, and up through the ground came a bubbling disbarment. This is a true story. Frank Sledge was employed first by White and Steel and then later by Holland and Hart. And I had actually considered offering him a job until an associate in the firm who had previously worked with him at White and Steel told me not to trust this guy and that he would get me in trouble. A few years later, I was watching the news and I saw Frank Sledge being filmed through the screen door of his house after it had come to light that he had billed 6,000 hours in 1 year. Obviously, that's ridiculous. It reminded me of the old story about the attorney who died and found himself just outside the pearly gates to heaven talking to St. Peter, and he was complaining that he had died at such a young age. And St. Peter looked at him and said, "What do you mean? According to your billing records, you're 74,000 years old." Whether that's funny or not, it points out that this is a sensitive area for lawyers. It's a subject of derisive jokes, and we're the brunt of those jokes, so we have to be careful. But this is no joke, what we see on this screen. Frank Sledge was disbarred, and what they found is that he had engaged in improper billing practices on multiple occasions, and the rule he was found to have violated was Colorado Rule of Professional Conduct 8.4C. So let's take a look at that rule, because if it's important enough that it could get you disbarred, we pretty much need to know what it says, don't you think? Well, Colorado Rule 8.4C basically talks about conduct that reflects adversely on a lawyer's fitness to practice law, as well as an attorney's honesty and personal ethics. The provision that was cited in the disbarment order for Mr. Sledge was 8.4C, and that one says it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. If you do a Westlaw search of this particular rule, you will find that the vast majority of published decisions citing this rule are disbarment proceedings related to excessive billing or mismanagement of client financial interests, including client trust accounts. This is the most common basis to disbar a lawyer that exists in the rules of professional responsibility. Now, before we move on, just notice that last paragraph H, even though it's not in boldface. It is professional misconduct for a lawyer to engage in any conduct that directly, intentionally, and wrongfully harms others, and that adversely reflects on a lawyer's fitness to practice law. Now, clearly, filing a lawsuit against another party could be construed as activity that intentionally and wrongfully harms others, depending on whose side you're on. But clearly, that's not what this rule is intended to encompass. We only offer this at this point in the process to get you thinking about the fact that these provisions in Rule 8.4C are broad and vague enough that they can be applied by a court as the court sees fit to attack any behavior that otherwise looks suspicious or unsavory. So let's take a look at another example, another real-life example. Here's the entry. Review pleading files to identify exhibits to be listed in the final pretrial order. Draft defendant In-Situ's exhibit list. Review in accordance with attorney instruction. Now, this was an entry made by a litigation support specialist, and I have absolutely no doubt that that person spent every minute of the 4 hours billed and probably more. The problem is that the entry has a couple of discrepancies to it that are worth noticing. One is that it's bulk billing, meaning that it's several different activities combined under one single time entry. If you review the Chubb billing guidelines, which are the gold standard that we have adopted as our firm standard, you would see that you'd have to break each one of these out into a separate entry. Giving you an example, as having rewritten them in the light blue boxes below, you can see what we did here is we said thorough review of entire file to identify exhibits to be listed in Final Pretrial Order. And the entry says 3.2 hours. Is that reasonable? Well, look at that. 3.2 hours. Is that a lot or is that a little? Thorough review of entire file to identify exhibits, which will obviously be used at trial? That doesn't sound excessive to me. What she had written initially was review pleading files, when in fact I suspect that she was reviewing the entire case file. So these nuances and these precision word usages become extremely important in terms of how they affect the client's acceptance level for the amount you have billed. Notice the second entry says, drafted initial defendant's exhibit list, and that should be the initial version of defendant's exhibit list, for attachment to Final Pretrial Order, 2.8. Now that entry may be a little bit excessive in light of the description, or it may not. But let's assume for the moment that drafting that exhibit list is seen on its face as something that could support 2.8 hours of time. If you make that assumption, then we have now supported with just the billing descriptions 6 hours of billable time, rather than 4 as originally billed. The point we're making here is not that she should have billed more time, but rather that using good descriptions, you can carry more weight in terms of how much time you bill. If you use the word weight to mean sustaining the pressure of the client's inherent suspiciousness when they review your bills. So again, the message isn't that she should have billed more time or used this tricky little gimmick to churn the file or rip off the client, but simply to show you that with good descriptions, the same activity can be presented to the client in a way that's far more acceptable. If you were to go back and assume that drafting the exhibit list would really take 0.8, which might be easier to absorb, in fact, it would be very easy to absorb 0.8 to draft an exhibit list on a major case, then you'd still be at 4.0 hours with nothing suggesting criticism or inviting criticism from anyone. Now here's another example. Study file materials, including complaint, answer, discovery responses, and briefing related to plaintiff's motion to compel in preparation for correspondence to plaintiff's counsel regarding disclosure of plaintiff's customer names. Now the problem with that description is that it does do an adequate job of supporting 2 hours of billable time, but it's a grammatically awkward statement. The clauses don't fit together in a natural way. So we can improve that entry. It didn't get bigger and it wasn't broken out into sub-entries, but read this as a possible alternative suggestion. Detailed review of key pleadings and discovery responses related to pending motion to compel discovery filed against the client for use in correspondence to be used as exhibit in discovery motions and hearing on same. Do you think that that's a better description? Even if you disagree, my hope is that by showing you this comparison, we're raising your consciousness to be alert to how these things operate at a psychological level in the mind of whoever reads your bill. Now here's another entry. Detailed study of plaintiff's responses to written discovery in effort to determine whether there is an opportunity to utilize court's order regarding In-Situ's customer names to request Hach's customer names and data. Now, on its face, that entry is fine. But taken in the context of the rest of the bill, it could be a serious source of trouble because it is duplicative of other work that was done by a different lawyer, and it's also a little bit vague for such a large block of time. 3.6 hours to look at written discovery responses may be seen as excessive without a little bit more breakdown. But let's assume that it's a fine entry. Notice that there was an earlier entry by a different lawyer that said, study file materials, complaint, answer, discovery responses, and so forth. And by the way, this is the entry we looked at on the previous slide. If you see that entry that's at the bottom of the page, and then you see the entry that we are now discussing, the two together could begin to look like highly duplicative work. When the client then notices that these were done by two separate lawyers, the immediate suspicion that almost every client who's paying attention to the bill would have is that we have duplication of effort going on because we have too many attorneys working on the case, and that the work that was done in the earlier entry that you see on the bottom could have benefited or informed the exercise that you see by the other lawyer in the top entry, and that it's bad management not to have given both of those functions to the same lawyer in order to avoid that duplication of effort. Now, the simple truth is that the attorney who did one of the entries was too busy to do both of these sets of work. How do you solve that problem? The answer is simply this. The billing entries have to be drafted in a way that doesn't just withstand scrutiny on an entry-by-entry basis, but withstand scrutiny in light of the overall total text of the bill as a whole. Also, from a firm management standpoint, it means that we need to be careful in how we parse out specific tasks and functions in a case so that we avoid the phenomena of three people doing the same job 3 different times and billing for it 3 different times. That's not so much a billing entry job as it is an overall management job, but it's important enough to warrant being mentioned here. Now let's look at this next billing entry. Draft memorandum detailing findings regarding opportunities within discovery requests to obtain Hach's customer names and develop strategy regarding same. Notice that that is very duplicative of the previous entry and, in fact, was done by a separate person. As an aside, please also notice that we have very awkward and convoluted language here. Opportunities within discovery requests. I think I understand what the lawyer was trying to say, but it simply isn't good writing. So what could have been said instead was drafted memorandum detailing findings from earlier research and file review regarding use of opponent's discovery position to require disclosure of opponent's proprietary information, and strategy with case law and specific references to pending motions and correspondence supporting the same. Now remember, this is an entry for drafting a memorandum. That's why listing all of these various attributes and facets that were included in the memorandum might make sense. But just as an exercise to help your awareness level come up about how this works, look at that bottom entry carefully. Ask yourself, if you saw this on a bill and did not know how much time was spent on it, what you would expect to see as a range of time, where I've got the question marks in the red circle. If you read that entry without knowing what the billed amount was, what range of values would you consider acceptable, just looking at the text? If you saw 0.2, you'd be surprised. If you saw 8.4, well, you'd probably be on the outer end of acceptability. That would be too much for a memo, unless it's a very lengthy memo, in which case the description should say, drafted lengthy memo. So, you might be getting the sense out of all of this that the answer is to make your billing entries as long as possible. Again, remember the slide we saw earlier where the ABA website suggests that the success of an attorney in invoicing a client is detail, detail, detail. Well, that's true, but there is a caveat that we want to cover right now, and that is the answer is neither sheer verbosity nor the use of narrative. I have seen again and again how lawyers will use sheer verbosity or the use of narrative as a sort of a camouflage substitute for actual detail. What do we mean when we say sheer verbosity, and what do we mean when we say use of narrative? Merely piling up words isn't the answer, and these are two ways that lawyers just simply pile up words without satisfying the need for real information in the billing entry. Here are two examples. Sheer verbosity. Developed strategy to compensate for credibility loss by client, including time for evaluation of multifactorial balancing test employed by courts in determining whether to strike or limit testimony rather than merely instructing the jury on credibility. What's good about this entry is that it would put a human reader into a coma before they get to the 4.8-hour figure, assuming that the human reader is an idiot and has a very short attention span. The problem is that some of the folks that read our bills are not idiots and they don't have short attention spans. If we only sent bills to idiots with short attention spans, you would not be asked to watch this video. We send our bills to companies that hire other law firms to go over our bills with a magnifying glass. That is a fact. Therefore, an entry like this, wordy as it is, that says absolutely nothing, may be completely insufficient to support a 4.8-hour billable time entry. So words alone don't get it done. Meaning and content get it done. Often, when we've pointed this out to younger lawyers or less experienced lawyers, it's like squeezing a watermelon seed between your fingers. It shoots out to the next less pressurized spot. And we see a narrative response. If you want information, I'll give you information. Prepared letter to client explaining that witness testified that while he was at the scene of the accident, he did not have his glasses with him, but felt that he could still see the color of the light, which he claims was red, and that he heard someone say that the light was red. 3.3 hours. Well, that's a narrative response. It's an attorney trying to use a billing entry in substitution for a status report. The fact is that information about what the witness said is completely inappropriate for a billing entry. It is very necessary in a status report read by the client before they get this bill. If the letter contains a complete description of what the witness said in a deposition, and the attorney has sent that letter to the client before the bill goes out, it would be sufficient to simply put in that latter entry, prepared detailed status report to client summarizing key developments in recent deposition of so-and-so. Again, the remaining text in the entry would have to justify a 3.3-hour entry, but if you send a 14-page report, believe me when I tell you that 3.3 hours will be acceptable. It is also not unreasonable when you write prepared letter to say prepared 14-page letter with detailed analysis to client explaining developments in recent deposition. That's a shorter entry that would do a better job of supporting the weight of 3.3 billable hours. Now, these two things, sheer verbosity and narratives, neither of these will get you in trouble, but they're amateurish. They don't project an aura of total professionalism. And so they're a little bit like shooting yourself in the foot. Why give up a chance to impress a client? Whether it's how you talk on a phone, how you send an email, how you write a text message, which hopefully you're not doing too much of in the practice of law, or how you write a billing entry, everything that you say orally and in writing is used as a measuring stick by a client in gauging just how top drawer you are as a lawyer. So why give something up for nothing? Why give yourself a disadvantage? Why shoot yourself in the foot? Now, let's look at patterns of billing instead of individual entries. We're going to conduct a little exercise here. Can you spot the problems in these sequences of entries? First of all, I want you to look at these time entries. Are they acceptable? Are they excessive? You've probably figured out that you cannot gauge the answer to that question without the text in the box. The only reason we've conducted this little thought experiment with you now is to make you utterly aware of just how important those words are. So let's take a look at what the words are. Study these entries for a moment. Does anything jump out at you as troublesome? If not, then either I'm not giving you enough time to review the entries, or you're missing the point of everything that we have said up to this stage. Please, if you have found difficulties in these entries, make a note of what they are. You may wish to stop the tape for a moment and discuss this slide before continuing. Here's a good example. Researched time for filing response to interrogatories. That would be an instantaneous red flag. Why? Two reasons. One, lawyers are expected to know things like this. That doesn't mean you shouldn't look it up. It means you should look it up and probably not bill for that time, because that goes to your basic development of lawyer skills. However, if you do bill for looking up how long you have to answer interrogatories and you put more than 0.2, that's abusive, because you should be able to find an answer to a question like that very, very rapidly. Let's look at this entry. Drafted letter to opponent confirming stipulation related to use of deposition at trial in lieu of live testimony, 0.8. We see these types of entries commonly. Are they the product of a lawyer being inefficient? Or are they the product of a lawyer trying to claim more billable hours than he or she actually spent? Or are they the product of a lawyer not realizing that the 0.8 hours that was spent consisted of more than just confirming the existence of a stipulation? If I write a letter that says, "Dear Mr. Blow, this letter will confirm that we have reached a stipulation that we will play the deposition of Amy Smith at trial in lieu of live testimony," I charge 0.8 hours for that, and somebody reads that letter later, I can expect disciplinary action at the worst, or client dissatisfaction at the best, or both. If that letter contains a lot more and would itself justify 0.8 hours, this billing description does not make that evident. So I may want to change the entry to say drafted letter to opponent confirming stipulation, etc., and further discussing other issues, which you then list. Now, summarizing everything that we've covered so far, we have these basic guidelines. Clients notice large time entries much more than smaller time entries. Therefore, when you break your entries out, you give yourself a much greater advantage. 6 entries of 0.2 are much less likely to get noticed than 1 entry of 1.2, particularly if the work that was performed can be traced in an audit of the file. Next, if the total time across several smaller entries for a specific project adds up to an excessive total amount, though that fact is less likely to be noticed in an audit, billing review, or by a client just scanning the bill. Once it's discovered, a problem like that is even more damaging. So while it's less likely to get caught, it's much more destructive if it is caught, because it carries with it the specter of a systematic problem rather than just one single billing entry that's a difficulty. Because it looks like across the board, buried in the bill, there is churning or abusive billing. So again, this is a much more dangerous problem, even though it's harder to catch on the part of a client. It is very important to be alert to and conscious of what all your entries on a specific project add up to. For example, if I have 15 entries between point 1 and point 4 for a project that add up to 10 hours, or whatever the number would be, and the total project should only take 1 hour, the fact that all those entries were small will not rescue me from what looks like a systemic and deliberate billing abuse. So you have to be careful about looking at entries in the context of the overall bill. Again, this leads to the next point. Duplicative, redundant billing entries are inherently suspect, whether or not they all attribute to the same timekeeper or the same attorney. Clients hate to pay for inefficiency, redundancy, or duplication of effort. If you break entries into smaller segments of work, the descriptions must make it obvious that there was no actual duplication of effort and that those individual segments are different from one another as you move towards the completion of an overall task where the total amount of billing for the total project is reasonable in light of what's achieved in that total project. Finally, all entries and complete bills have to be able to pass the smell test. And remember, the smell test is just a slang term for the overall gut sense someone gets when they look at the bill. Even if there's no entry or group of entries that could be directly subject to criticism, if your bill gives the client a queasy feeling in their stomach, which usually comes not just from the amount, but some overall systemic flaw in the way you're billing, you can lose a client. This is why law firms put such a high premium on the trait or property of an attorney that we call good billing judgment. Now let's take a look at a few enhanced ideas that go with those main guidelines we've just covered. Billing entries must describe activities actually performed rather than circumstances or reasons, but implicit in the way they're written, those circumstances or reasons may come through. They may justify the time, but they have to be implicit rather than explicit in order to avoid some of the difficulties we've covered so far. Next, entries for out-of-office things like hearings, depositions, and meetings are inherently less suspect because it's implied that the lawyer had little choice in how long it took. Again, use the analysis of a lengthy hearing. Even though nothing was accomplished for the attorney, everybody knows the hearing takes as long as it takes, and the lawyer has no choice but to be there and bill for it. Next, the flip side of that is this. Entries for review, research, analysis, evaluation, summarizing things, and so forth are inherently suspect because there's no clear standard as to how long such things should take, and they tend to take a long time. That's where the billing description artistry we are asking for you to apply becomes essential. Let me restate that. The basic skill with which you draft and craft your billing entries for things like review, research, analysis, and so forth is probably the single most important thing in keeping us out of trouble with the way we bill. Next, professionalism in the wording of the entries makes all the difference. Awkward language draws attention. Large entries with short descriptions draws attention, unless it's for out-of-office things like first day of trial, 12.5, or something of that type. Finally, always expect your bill to be audited. We've seen lawyers slap time entries in, hoping not to get caught when they haven't spent enough billable time to satisfy the firm's requirements and or be lazy, even though they are putting that time in how they draft those entries. In both of those cases, the problem appears to come from the fact that the lawyer thinks no one will notice. The problem is people do notice. That's why you've had to watch this video. And for that time that you've spent, we thank you.